Hello, dear friends, and welcome to another episode of the Strategy International podcast. Strategy International, for those who don't know, is a global think tank that brings together great minds from all over the world that reflect, analyze, discuss, and research different topics of global interest, such as international relations, policy, strategy, defense, the economy, and much, much more. You can visit strategyinternational.org for all information. And of course, speaking of great minds, we have another great episode today. We have Dr. Eleni Gavriil with us. She is a lecturer in international economic law and human rights at the Department of History, Politics, and International Studies of the Neapolis University in Paphos in Cyprus, with specific expertise in international investment agreements, the promotion and protection of foreign investments, and the protection of human rights. Eleni, thank you so much for being on the program.
Thank you very much, George, and the whole Strategy International team. Today, I would like to discuss about the protection of foreign direct investments.
This is very exciting for me. And just before we get started, I'm excited first and foremost because, like you said, we're going to talk about foreign investments. It's a topic that I personally am not very much familiar with. So I'm excited because this will be somewhat of a learning experience for me, as I'm sure it'll be for a lot of the people listening or watching. I want to start for just very basic, for people that don't have PhDs on the matter. What does it mean when we talk about foreign investments? What is this concept? What does it mean more specifically? What falls under this umbrella? Is it investing in global markets, investing in government bonds? Is it more in the private sector? For example, I come to Cyprus and I invest in a chain of restaurants or retail stores, or is it more in the public? Like, for example, investing in government-led initiatives and exploring natural resources, or government subsidized incentives in developing the high-tech industry or green technologies. Just give us a little understanding, a basic understanding of what we talk about when we're talking about foreign investments.
Okay, so let's start from the beginning in order to understand what we're talking about. In general, international investment law is the field of the law that regulates relations between states and investors, usually multinational corporations. So when we discuss about foreign direct investments, we talk about a very specific kind of project, let's say. It's not the same as portfolio investment, and it does not have a specific definition, a uniform definition. But based on the case law of investment tribunals, foreign direct investments have some specific characteristics. These are found in the case of Salini versus Morocco in 2002. So first, foreign direct investments must show substantial commitment, contribution. So we must have personnel, funds, huge amounts of money given to a specific project. Also, we must have a medium to long-term duration. For example, a project for 2-3 years is not considered foreign direct investment. We are talking about projects that last 20-25 years.
Okay.
Also, there must be an assumption of risk because we are talking about long-term projects, so there must be specific risks that the investor faces, and also a significance for the development of the host state. There must be a contribution to knowledge, to expertise towards the host state. So we are not discussing about portfolio investments or small investments that you and I may make. We are talking about big projects in the extraction field, the extraction of natural resources, this kind of projects.
Why, explain to everyone why it's important for countries to have foreign investments.
This is a promise that we hear all the time when we have elections coming to a country. Usually politicians are saying that we are going to attract investments, vote for us, and we're going to bring money, we're going to bring investments into a country. This is true. Investments play a vital role in the economic development of a country. They are very crucial because they can help economically, but also socially country. They can bring stability. They can provide expertise to the population that is working in the project, education, infrastructure. So they are indeed very important for countries to attract a lot of foreign investments and bring money to the country and as a result to the population as well.
It must be a very complex process, because obviously for someone to want to invest, like you said, it has to be more of a long-term project. There has to be a long-term vision with the risk assessment and everything that follows. And for a foreign investor to go in, obviously there needs to be the right context, politically, economically. So there's a huge responsibility that falls on the government's shoulders to make sure that the climate in the country or in the state or wherever their whatever level of government is unique for these investors to have trust in, the whole infrastructure that comes behind this investment.
Exactly. When a corporation wants to make a project, to make an investment, they will look into each country to see how favorable the conditions are for them. There are countries that are a lot more risky because they may violate the rule of law. There are incidents of bad governance, and there are countries that respect the rule of law. They have very transparent and good governance bodies and infrastructure. So to this end, they will be more attractive because it gives the confidence to the investor that they have less risks, let's say, less danger for the investments to be violated, for the rights to be violated. So when an investor wants to make an investment and proceed to a project, they will look into the risks of each country in order to understand what exactly they have to face when they go into when they proceed with a project. Risks are threats, and each country has different threats and risks that it faces. So it is the laying down of risks is connected to which country they are going to choose. And these risks are related to each country specifically. We have several kind of threats and risks. We can give some examples if you want. So usually they are connected with the political environment of a country. Commercial risks are let's say, taken by the investor. So when we are discussing about risks, we are looking into the political risks, change of government, political instability, this kind of incidents. So some cases, some specific categories of risks is, for example, political hostility, which is usually ideological. We know that some governments are ideologically against foreign investments, for example, some communist regimes. So this will constitute a specific threat to the investor, because when they proceed with an investment with a country that it is against in general or against foreign investment, they will have huge danger of their property being expropriated. We will discuss about it later, about this specific case. Other type of risks are nationalistic concerns. In a lot of cases, governments want to take over specific business sectors to keep them national, and they would not want foreigners being in specific business sectors. Water privatizations, telecommunications, several investments. In other cases, governments may want to change the contracts that the previous regimes have made because they're against it. They believe that they were made by means of corruption. So we can understand how many dangers and risks foreign investors face when they decide to proceed with a project.
It's interesting because, and it reminds me of a story that I'd like to share, because you're talking about circumstances that are probably common in countries that have unstable governments and regimes. You mentioned about communist countries, but there's a lot of these issues that also happen in countries. For example, where I'm from here in Quebec, I remember a specific story. There's the government between 2008 and 2012 had this huge incentive in developing the northern part of Quebec, which, for everyone that doesn't know, Quebec is very rich in natural resources. And there was this incentive in bringing all these foreign investors into Quebec so that they can develop the northern part. Obviously, we're talking about natural resource extraction, road infrastructure. There was a whole tourism industry development project as well. And everything was going well. It was we're talking about hundreds of billions of dollars in investments. And in 2012, the government switches. And there's another party that comes into power, which is more, it's the party that wants to separate Quebec from Canada. And everything was set. Everything was ready to go. And they just could not agree on the dividends or the formula of these foreign investors. Who's going to take what? Do we profit from the natural resources themselves, or do we just get paid for the work and then the rest stays in Quebec? You mentioned about nationalization. So that formula couldn't work out in a matter of 18 months, because that's all that government stayed in power for. Everything crumbled. The entire project fell through the cracks, and it just disappeared. An incredible project like that. So it's not only in countries where you have unstable government, even in a country like Canada that's considered to have dynamic government structures, you have these issues that happened, and you're talking about this, and it brought back this story for me because people still talk about that.
It's we usually connect risks with developing countries. However, as you said, risks are also found in developed countries, in the United States, in Japan, in France, in Canada, as you mentioned. There are risks for investors everywhere. And this is why it is important to mitigate those risks and minimize those risks. It's very common for politicians to come to our country, invest to our country, but then after the investment, usually things change, and there is a lot of hostility against investments. So this is why it is very important for investors and investments to be protected, to be safeguarded. And this is how the whole investment law field has developed and grown, because it was very important to protect investors and investments, because they are in a vulnerable position against the host state. This is the basic of investment law, the vulnerable position that investors and investments are, and this is why it is recognized that they must be safeguarded and protected.
These, speaking of which, the safeguards that are in place, are these unique to each country? For example, if I'm interested in investing, in getting into foreign investments, do I have to comply with each country's specificities, or are there international sort of agreements that each country ratifies, and that way it makes it sort of uniform across the globe, whether I invest in the US or Canada or in Europe or whatever? There are certain foundations that are there, legal foundations that are there, that are known, and they are kind of generalized.
The uniqueness of investment law is the fact that we do not have a central treaty or institution, as we have the World Trade Organization, for example, in the context of trade. We have bilateral investment treaties, over 3,000, and each one is different. However, there is a specific basis. There are specific standards of protection, which are found in almost every investment treaty. These are protection from expropriation, the fair and equitable treatment standard, the protection from discrimination on the basis of national treatment and most favored nation treatment, and also the full protection and security. So these standards are the ones that we found in almost every investment treaty signed by states and investors.
Okay, let's go over those in detail. What does this mean? So when we're talking about bilateral, multilateral treaties, what do we have in this category? What are we looking at?
Bilateral treaties are the treaties that countries sign and where we find the standards of protection. And on the basis of these treaties, we can understand how high the protection of an investment is. So the most basic standard of protection is protection from expropriation. It is one of the oldest concepts in international law, because foreigners were always worried about the fact that their property is going to be taken over by states. So expropriation is the taking of property. It is a well-recognized rule in international law that property cannot be taken without compensation. However, we must say that, of course, based on the right of sovereignty, countries have the right to expropriate property, to take property, however, only based on specific conditions. These conditions are that the measure must serve a public purpose, for example, in order to protect the environment. The measure must not be discriminatory against the specific investor. Also, it must follow the rule of law to have the right to a fair trial and to appeal, for example. And also, compensation must be given. The compensation must be prompt, effective, and adequate. So, expropriation can be taken, however, based on these specific conditions.
I have a question for you, and maybe people watching or listening may have a question based on what you just said. We saw, over the last year with the conflict happening in Russia and Ukraine, how all these countries, made this, this alliance in sort of, quote unquote, punishing Russia with different sanctions, etc. But we saw in different countries these governments seizing different Russian assets, whether they be businesses or whatever they may be. Does that fall into this category, or is it something completely different?
It falls into this category if it was a foreign direct investment.
Mm-hmm.
However, still the sanctions regime is another regime. Mm-hmm. It is based on the Security Council decisions, on the European Union decisions. But when we have the seizing of Russian property, which is constitutes an investment, yes, it may fall under this category. And Russian corporations, if they feel that their rights have been violated, they will bring a claim against the specific host state, for example, Cyprus or Greece or Canada, in order to ask for compensation, because they want to claim that their rights have been violated.
All right. So what can happen in these circumstances? Say a government seizes, foreign property or foreign assets. Can it then sell them off or keep them, or how does it work?
Usually they keep them, but this kind of expropriation was found mainly in the 60s, where governments took over of the entire property of a multinational corporation. Today, we have new forms of expropriation because governments do not want to show that they are hostile against investors. Right. So they have found other ways, to cover up a bit of violating investors' rights. So what they do is usually they raise taxes to a great extent, or they change the regulation, they do not renew permits. And to this end, the project cannot continue because it does not have, let's say, a permit to continue working. This is still expropriation. This is indirect expropriation. And it's all the new forms that we see today happening. So direct expropriation is a rare phenomenon today. There are still some cases in Venezuela, for example, but we mostly see it through the raising of taxes and changing of regulations. Mm-hmm. And when this happens, the investment may lose entirely its economic value. And of course, the investor may ask for compensation at an investment tribunal.
When we're talking about tribunals or arbitration or anything like that, what law takes over? Is it the host country or is it the investor's country's laws?
It's based on the international agreement.
Okay.
So whatever the agreement says, it will be followed by the tribunal, because arbitration does not go through national courts. Mm-hmm. This is why it is very friendly towards investors, because they do not have to go to the national courts, which may be a bit hostile or against them. They go to a specific arbitration tribunal with arbitrators that they may have chosen or not. And it gives them a very flexible and quick way of settling disputes.
Interesting. I want to talk a little bit about, different strategies on protecting these investments. How does that, like, how do both host countries as well as investors make sure that what they're going into is safe and it will be protected?
Investors will look, both parties will look the contract. The contract can be negotiated. The agreement can be negotiated. So it is very important to have an agreement which has been negotiated and agreed by parties. In a lot of cases, they rush into, especially states rush into the agreement because they want to proceed with the investment. However, it is very important to have an agreement that lays down in concrete way everything, so they know what to expect. The more transparent the framework, the better it is for both parties.
In your experience, and in your knowledge, obviously, are there countries or regions that are more favorable for foreign investors than others? Obviously, we mentioned, hostile countries that have unstable governments or questionable, regimes. But aside from those countries, are there any other parts of the world or regions where these conditions are so transparent and so easygoing that it's more favorable than other countries?
It's countries of the European Union, developed countries in general, and actually there are some. If someone would like to look into that, there are some lists online where you can see specifically how safe the environment of each country is. So there is a rate, and based on this rate, it shows you how safe or not safe it is to do an investment in a specific country. For example, Cyprus, which is considered a safe country. However, due to the occupation of Turkey, it has a bit higher risk because of the situation. Right. Or if in a country there are a lot of demonstrations and riots, this brings down the rate of a country. So the most stable countries in general, politically, socially, they are the safest as well.
You mentioned in some documentation that you sent me while we were preparing for this podcast, certain terms with respect to the protection of foreign investments. I'd like to go through them, maybe so that we can explain to the people listening or watching what they mean. Maybe not every single one of them, but you mentioned about we spoke about protection from expropriation and fair and equitable treatment. I think everyone pretty much understands that. But when you're talking about full protection and security, what does that mean?
This is one of the most interesting standards of protection for me. It is a bit debatable standard. We will see why. So the full protection and security standard, as the name says, it protects investments and investors from physical harm, also legal, but we will focus on the physical, which is more well developed in international investment law. So it mostly concerns cases where riot groups, armed groups, or police authorities, the military, will physically harm either the investment or the investor. Incidents of violence, incidents of looting, this kind of situations. So it mostly concerns on how the investor as a person and how the investment as a property are protected by incidents of violence.
So the host country has to guarantee this sort of protection and security?
Yes, it's not an absolute. Standard. So this means that not in every case that the investor or the investment will be harmed, they must give compensation to the investor. However, the state organs must do whatever they can to protect physically the investor and the investment, and it relates both to state organs, police, and also third parties, for example, rioters or looters.
Interesting. Okay, what about the national treatment standard? Or no,
the national treatment standard and the most favored nation standard are connected with the principle of non-discrimination. So according to these two standards, all actors must be placed in an equal position, so they're not being discriminated against. We know from the early of the years that countries tend to discriminate against foreigners. This is an often phenomenon. It also takes place in the context of investments. So based on the national treatment standard, there must be equality between competitive equality between national and foreign investors. So two investors, a national one and a foreign one that operate in the same operation, in the same business, they must be treated in the same way by the state.
Interesting. And what's the difference between that and the most favored nation treatment?
This is the most common question by students. It's usually a point of confusion. So the most favored nation standard ensures that all parties are in the same position. So it relates to how a foreign investor is treated in accordance with a third foreign investor.
Okay, I understand. But essentially, it still falls under the same category of having equal treatment.
And not discriminating against foreign investors.
Okay, interesting. What else do we need to know about foreign investments?
One relevant topic and also a bit debatable connects with the full protection and security standard. It is how investments are protected during armed conflict.
Oh, interesting. Yes.
Because conflict is ongoing in the world. We see also the case of invasion of Russia in Ukraine. So it is important to understand how and if investments are protected when an armed conflict takes place. There is not a specific answer to this. Spoiler alert. Yeah. So let's start by saying that investment protection is not automatically suspended during armed conflict. This means that countries still have the responsibility to protect investments as far as they can. So when we have an armed conflict, it does not mean that investors must not be protected by states. However, in some cases, standards of protections are not applied in the same way as before. Some treaties have the so-called war clauses, which limit the protection to a certain degree, because it is understandable that during armed conflict, during times of violence, it is not easy for the states to respect the standards of protection. And the most challenging topic is what happens with aggressors, third states. We said that the state of the investment has the responsibility to protect the foreign investments by physical harm. But what happens when the aggressor is a third state? For example, in the case of Russia in Ukraine, we have, let's say, Canadian investment in Ukraine, and Russia is the one that harms the investment. So what happens then? There is not a definite answer to this. Different rules of international law may be applied. It is very challenging, and creates a lot of challenges on how to protect these investments. So we do not have a specific framework in times of armed conflict. Nevertheless, what we have to remember is that rules of investment law do not automatically suspend at times at conflict. And there is a case actually similar to this, it's AMT versus Zaire, where the tribunal concluded that the Zaire had the obligation to protect the foreign investment from armed forces. So there was still the responsibility to protect the investment.
So in a case like this, for example, where they have that responsibility, how is that responsibility conducted when the government is, for example, a hostile government or a dictatorship that doesn't necessarily recognize the international tribunals or whoever does the arbitration in this case?
The case will go to the tribunal, to an investment tribunal, because for a fact the investor will want to claim their rights. However, if the decision is against the host state has responsibility to pay the award, the compensation. Mm-hmm. They must have thought about that before going into contract, maybe. But after that, if they do not pay the compensation, no corporation will go into the country and make an investment. Right. It's what we said in the beginning about the favorable investment climate. Mm-hmm. And today, countries that in the past were against foreign investment, so they have changed their view concerning them because they understand how important they are for the economic conditions of a country.
Just so we can wrap it up, I don't want to take a lot of your time. Is there any case either that you know of or perhaps even that you've worked on that was so important in its legal aspect that created a certain jurisprudence or a precedent, and it kind of shook perhaps the foundation of these treatments, of these treaties, or that pushed a sort of reevaluation of how to conduct the legal foundations of foreign investments?
One case that I find very, very interesting personally is the case of Philip Morris versus Uruguay. The Philip Morris, the tobacco company. Mm-hmm. So we said that the countries are under the obligation to respect investment treaties. In this case, Philip Morris made an investment in Uruguay, where in the tobacco field. And Uruguay is a country with very high percentages of smoking. So they decided to take some measures in order to protect the right of the population to health. All these signals that we find in
On the
cigarette
packages, yes.
packages. Yes, exactly. And Philip Morris claimed to the tribunal that Uruguay was violating the investment treaty because this led to an economic loss of the company. Because these measures amounted to economic loss. Usually, in previous cases, the tribunal will go with the side of the investor. But in this case, it's one of the unique cases, the tribunal took the side of the host state. The World Health Organization also took part in this proceeding, and they found that Uruguay had indeed the obligation to protect the right to health of its population. And this means that there was a reason for taking these measures. And so it sided with the side of the state, which is also a very small country in comparison with the corporation of Philip Morris. I think it's very interesting because it shows them the way forward in the field, that other aspects must also take into account, not only the economic aspect, but also environmental rights, human rights. So I think it's very interesting.
Oh, no, for sure. It's very interesting because this basically opens the door, and I don't know how long ago this was, but it opens the door to other sectors as well. For example, health, food security, and food. We're talking about food health, like, for example, all the fast food restaurant chains and all this sort of investors that have perhaps a negative impact on citizens' health. Yeah, it's fascinating. I mean, do you think that eventually it'll spill over into these other industries as well?
Until now, because tribunals do not have to follow the previous tribunals' cases, it's not very evident that we see this kind of approach. However, it is a step forward, a different scenery in the field.
Definitely.
This is why it's also interesting for me.
Very fascinating conversation, Dr. Gavriil. I want to thank you again for the time that you took to share your knowledge with our listeners and our viewers. Invite everyone again to go and visit strategyinternational.org for all the beautiful things that are being done over there. Where can people reach out to you? Where can they follow the work that you do? Where can we lead them to?
They can find me in the site of Neapolis University Pafos, where I teach, also social media, LinkedIn, and reach out to me to continue this conversation.
Fantastic. Thank you so much again. And thank you to everyone for tuning in. We'll see you all in the next episode. Thank you.
Thank you very much, George, and the whole team. Hope to see you again soon.
Definitely. Looking forward to it.
Bye.